Thank you, Mr Speaker. I rise on behalf of the Greens to express our deep concerns about this bill. It is yet another in a long line of draconian actions from this government that do far more to damage our civil liberties than they do to protect public safety. The object of this legislation is to allow for the continuing detention powers aimed at suspected terrorists. This law penalises future crime rather than any actual offences committed by a person. The Greens have a strong and principled stance that believe that keeping people in jail for a crime they have not committed is an extremely dangerous erosion of our civil liberties. Continuing to impose punishment after any period of incarceration has been served is simply wrong. It is clear that people in the community fear acts of terrorism. The act of terrorism is designed to create fear. And the response from governments to be able to address the fear that people feel is not to let that terror be propagated by actually introducing measures that create more fear within our community, by talking up the risks and the terrors that we face, and by winding back human rights and civil liberties and principles of justice and freedom that we should be valuing. The terrorists win when we pass laws like this that wind back our human rights and civil liberties. This is not the way that we address terrorism, and it is not the way that we respect fundamental human rights. But it is not just the Greens that believe this. The New South Wales Bar Association have consistently opposed the statutory high-risk offenders regime, and they have said that amendments proposed will extend the cohort of offenders caught by the Act, remove safeguards, and are contrary to established sentencing principles. The New South Wales Council for Civil Liberties strongly opposes the post-sentence continuing imprisonment of persons. I note the Minister's interjection saying that he is, in a sarcastic way, saying what a surprise that the Council for Civil Liberties opposes it. How wonderful that there is such respect from this Liberal government for organisations and groups in civil society that stand up for civil liberties and human rights. It is absolutely offensive to see that organisations and groups that have been attempting to prevent the wind back of civil liberties would be spoken about by this minister in such a way. No wonder they are concerned. No new crime has been committed and no trial has been held. This raises serious issues for the Council for Civil Liberties in relation to the fundamental right to freedom from arbitrary detention and long-established common law understandings relating to the right of a fair trial and the role of the judiciary in our justice system. It is indeed a dangerous trend. A central problem with the continuing detention regime is the inherent unreliability of any known risk assessment tool or process to determine whether a person is likely to commit a future terrorist crime, unless they clearly indicate that this is their intention. If so, they can be charged and tried under existing terrorism laws. A combined submission from a number of the councils for civil liberties across Australia addresses the fact that this bill is unjustified and a serious encroachment on the fundamental rights of liberty to the person and on the rule of law. We have specific concerns about this bill. We are concerned about how this bill will apply to convicted terrorism activity offenders and convicted underlying terrorism offenders. The definition of this is extraordinarily broad. Clause 10.2 makes it clear that the offender does not even have to have been convicted of a terrorism offence for the conduct concerned. Clause 11 sets out that the test for determining whether an individual is a convicted underlying terrorist offender or a convicted terrorism activity offender. Once again, this test is extraordinarily broad. H describes that in any intelligence regarding the offender's associates or affiliations can be considered, and J prescribes that any other information the court considers relevant will be considered. As it is written, this law would apply to somebody whose workmate was in a terrorist organisation, or whose friend was in a terrorist organisation, or whose cousin or child or sibling was in a terrorist organisation. They may be in jail for unrelated offences, but any association or any affiliation with any persons or groups advocating for support of terrorist acts is enough for somebody to be caught up in these changes. That is a seriously disturbing change to our laws in New South Wales. Clause 21 sets out that the Supreme Court is not required to be satisfied that there is a more than likely risk the offender will commit a terrorism offence, and suspicion alone appears enough for an extended supervision order to be applied. Extended supervision orders can be imposed for up to 3 years, but nothing prohibits the Supreme Court from extending orders indefinitely. Clause 29 sets out the conditions that can be imposed on individuals, the subject of an extended or interim supervision order. Individuals may be electronically tagged and monitored. Enforcement officers are permitted to visit the offender's home at any time, seize their electronic devices and their data, and seize other personal items the individual owns for a forensic examination. Part 3 of the bill sets out the process for making continuing detention orders. Continuing detention orders allow individuals to be imprisoned for up to 3 years after their sentence has expired. Nothing prohibits the Supreme Court from extending orders indefinitely. And Clause 35 again sets out that the Supreme Court is not required to be satisfied that there is a more than likely risk that the offenders will commit a terrorism offence. Suspicion alone appears enough for a continuing detention order to be applied. Clause 39 sets out the process the Supreme Court must follow when determining the application for a continuing detention order. 39C says that the safety of the community must be the paramount consideration of the Supreme Court. Once again, civil liberties are eroded under the guise of community safety, trumping all. My colleague in the other place, David Shoebridge, has expressed his clear concerns about the bill. He has said that these are thought crimes where the evidence will be given by prison officers with minimal regard to essential legal principles such as the presumption of innocence and credible independent evidence. He has said that we are letting terrorists win if we just make the fear of them makes us give up what makes us a fair and free democracy.
That's a good point.
The Greens cannot support this bill.
John Howard said that, actually.
I appreciate that frustrations of the Minister and the Liberal government when we come into this place and time again we oppose their attempts to look like they are being tough on law and order and that they are acting on terrorism, but the Greens will not cave in to the fear that they are trying to whip up around this. There are genuine solutions to address the terror and fear inflicted by radical terrorist acts in our community, and introducing legislation like this, which is basically creating a parallel criminal justice system based on rumour and innuendo and suspicion and prejudice. We do not support jailing people for offences they might commit in the future, and there are already a raft of criminal offences to capture anybody who plans, conspires or takes any steps to further a terrorist offence. These laws will not make us safer, but they will undermine efforts at rehabilitation and fundamental principles of common law, and they will further erode the protection of human rights and civil liberties in this state, which makes it an absolute shame, but unfortunately something that we consistently see from this Liberal National Government.
And the Labor